and we are set to call the meeting to order. Thank you.
Okay, this is Commissioner Galen Payton, and I will call the meeting to order. Agenda 1 is called the order. It is 9:30 on December 17th, and I call this meeting of the Citizens Clean Elections Commission to order. And we will go through the roll call and let me know if you are here. Commissioner Chan.
This is Commissioner Chan. I am here.
Welcome. Nice to see you. Commissioner Kimball.
I am here.
And I believe Commissioner Meyer and Commissioner Titla are not present. And so I'm Commissioner Galen Payton, the chairman, and I am here. So item 2, discussion and possible action on minutes for the November 19th, 2020 meeting. Any discussion?
Mr. Chairman, this is Commissioner Chan.
Yes, go ahead.
I'd move that we adopt the minutes as written.
Do I have a second?
Commissioner Kimball, second.
Okay, so was that for both August and October meetings?
Oh, I'm sorry, Mr. Chairman. On the agenda, it just says the commission minutes for November 19th, 2020.
Okay, so my notes say something different. So we'll just go with that then. So we have a motion and a second to adopt the minutes for November 19th, 2020. And we'll start voting. Commissioner Chan, how you vote?
I vote aye.
Commissioner Kimball?
Aye.
And this is Commissioner Payton, and I vote aye as well. The motion passes. Item 3, discussion and possible action on executive director's report. Mr. Collins.
Yes, Commissioner, Chairman Payton, Commissioners. I will try to get through the agenda fairly, go through this part of the agenda fairly quickly. Just a quick preview with respect to the rest of the meeting, and those of you who are waiting for the item, I think it's 6. I think we should be able to get there fairly quickly. So we had the electors met on December 14th, and you can see in the report some of the activities that happened leading up to that in terms of the canvas and other aspects. We did as you all know, we did a letter, thanking the voting community and the election officials and others for their efforts in this election. We do continue to follow up on many of those kinds of educational and informational opportunities. And as you can see, working through this month, the voter education team will be plugging away really right through the end of the month, and has been. Couple of quick points for us. I just want to make. If I can figure out how to use my mouse here a second. The one other thing I wanted to really mention, we are, as far as our regulatory agenda, you'll see there that we've identified, what we think is going to be our main regulatory agenda for the coming year. That's something that we will post on our website, and part of that is just part of the process of some of the things that we boxes, frankly, that we need to check off in terms of notice for purposes of the rulemaking process now. And right now, as we look at things, we think the main thing will be to make sure that we to evaluate and determine if there's any rules that we need to update because of that Court of Appeals decision that we got in October, I want to say. And we know that some of those things we were ahead of the game on in terms of the rules we adopted in like 2017. Other things will definitely have to change. So, and then I hope to get in contact with the Governor's Regulatory Review Council staff, hopefully soon in the new year, to make sure we're on track there. So, really not a lot to report other than our ongoing, voter education activities. But if you have any questions, commissioners, I'm happy to answer them. Thank you. I'm sorry, Mr. Chairman, I think you're on mute.
I was on mute. Any comment from the audience on this item, you can signal the moderator if you have any comments. If not, then moving on to item 4, discussion and possible action on 2021 calendar year budget. And Mr. Collins is going to begin our discussion, and Mike is on hand if you have any additional questions. Go ahead, Tom.
Yes, thank you, Mr. Chairman. We are, every year, as I think all of you have gone through this for at least 4 years. Basically, what we do is the statute obligates us to make some projections about, what the fund looks like, what our projected expenses are, and make those calculations on a formula basis. And then because the statute sets up our budgeting, sets those caps around calendar years, it follows from that our budget follows a calendar year. So what we have done here, as we have in prior years, is identified those things that are calculations that are required to be done by statute, and then included in that also our anticipated budget for the coming calendar year. A couple of things I would note. First, obviously there's not going to be candidate funding in this calendar year because candidates cannot file for 2022 until January of 2022 for their funding. And then I think the other thing I just want to make a quick point about is that, there's two things. One, as we always see on this memo, there is a structural, if you will, well, structural is not the right word. There is a projection we have to do that continues to show the fund in deficit if we spent at the maximum allowable under law. That projection is required by statute, but that's not a true deficit because we don't spend at that level. It's just if we spent at the statutory capacity. And then the other point I think is worth stressing is that this is not a calendar year appropriation that rolls over. Rather, the way that the statute operates is that the surcharge that funds the act is collected. The treasurer is directed to place those dollars into the Clean Elections Fund, where they remain because they are appropriated explicitly by the statute, by the voters. So, with that background, I think that other than obviously in these off years we have a reduction in our overall spending. We don't have anything that we think is necessarily. I mean, basically I turn it over to you all to any commissioner any questions or comments. Also note that programmatically, we anticipate coming to the commission with our voter education plans for the coming year in the coming year. So once we've made this determination about the budget, then Gina and her team will and Paula will work on the that process. So at that point, Mr. Chairman, I would if you have any questions or comments, we're happy to answer them.
Any questions for Mr. Collins from the commission?
Yes, Mr. Chairman, this is Commissioner Kimball.
Yes, Commissioner Kimball, go ahead.
Mr. Collins, I don't want to get too much into the weeds on the budget, but I looking through it, the total expenses are up substantially, more than twice what they were last year. And I can see personnel services are going up substantially, data processing. Could you just talk about some of the reasons for going from total expenses of about 670,000 to about 1.4 million?
I would, I'm going to ask Mike to rescue me on this.
Mr. Chairman, Commissioner Kimball, a couple of reasons the numbers look a little bit off. One, the full amount that the commission has spent in 2020 has not come in yet. So when you're looking at the actual numbers, comparing it to what we're budgeting, the actual numbers are going to increase. We do not have those numbers for December, and we will have more numbers in January, so that number will increase. As far as your external data processing, that number has increased quite a bit for both the voter ed side and the admin side. And the reason for that is there's a couple of reasons. One, we're moving from the way we handle our service and everything like that we're going to a cloud-based system for the state. And there's a lot of detail that is being worked out by our IT group, and there's a lot of work on that. So we're budgeting quite a bit more than we think is going to actually be needed, so that we don't have to come back to you time and time again. Secondly, we are also having to update our systems on our individual computers as well as our laptops to do security upgrades and to get more software that are more compatible with what we're doing at the state. So that's why those numbers have increased. But overall, you will see our actual numbers will go up at the end of this month and in January when we get final numbers for what the commission spent for 2020.
Okay, and one other question I had, the last page of this budget thing, candidate funding projections. In 2018, it was close to $9 million to candidates. 2020, it was $2.9 million. Is that substantially because there were outside the Corporation Commission, no statewide races, or are fewer people signing up to be clean elections candidates?
Mr. Chairman, Commissioner Kimball, it's both. We do expect more candidates because it's going to be another statewide race for the governor, secretary of state. So we do expect it to increase a bit, but not to where it was several years ago. We don't have the numbers that we used to have, and this year was only Corporation Commission running as a statewide, so that's why.
So, is it right to say there's been a steady decline in interest in being a so-called clean candidate?
Mr. Chairman, Commissioner Kimball, when matching funds went away several election cycles ago, we had a dramatic decline. Now we've seen a steady rate of roughly somewhere between 28 and 35 candidates running using clean elections. That may go up a bit with more statewide offices open in 2022, but we expect in that range again.
And if I could, Mr. Chairman, Commissioner Kimball, just add a little onto Mike's point about that. With respect to participation, I think there's two other issues that we don't know. I think Mike's right that we have reached a point of stability. What we don't know in a given year, we've had now since 2016, we had the 2016 election cycle, 2018 election cycle, and the 2020 election cycle. Those election cycles have all been under different regimes, campaign finance wise, as applied to the Clean Elections Act. The first being in 2018, we were under the same rules as we now will be under following the Court of Appeals decision. And then in 2020, it was our first year under Prop 306. And we know for a fact that there have been wild misconceptions about the effect of that act and active discouragement of folks running clean because of it. Whether that's, that is a true statement that those two things have occurred. Whether or not those inaccurate portrayals of the law will change people as they're corrected, will change people's behavior. And now that the Court of Appeals has settled, a couple of the major outstanding issues related to that, we may see some changes in 2022, one way or another. But we have not had a stable legal regime in place under clean elections or under the campaign finance system as a whole since 2016. It's changed every cycle. So it just makes it a little harder for consultants and attorneys who have to make the kind of decisions and advice they might otherwise. So that's just my 2 cents. The facts are the facts. My inferences from them are subject to your own point of view.
Well, I guess I don't want to get too much into it today, but it seems like a topic for future discussions about, are there things we can and should be doing to encourage more candidates to consider running as clean elections candidates.
Oh, yeah, Mr. Chairman, Commissioner Kimball, I agree. I think that in this off year or off 9 months, if you will, I do think there'll be some opportunities to, with the Court of Appeals decision and with the rulemakings we'll have to do, as I mentioned in the executive director's report, and then with a year under Prop 306, a cycle under Prop 306 done, I think that we will be in a position to start to address some of those things by communicating them in part to, the folks who are involved in this process on a sort of day-to-day basis, at the very least.
Thank you, Mr. Chairman.
Sure. I might add that maybe we could do education to prospective candidates to before planning for this could start for them, to let them know that we're available and how clean elections can help them with their campaign. Since we've been doing voter education, maybe we could do candidate education. Any other comment? Any comments from the public? Okay. If there's no further discussion, I'll entertain a motion to adopt the memorandum at pages 1 and 2 of item 4, setting forth the commission's projections for the calendar year.
Mr. Chairman,
Yes.
so I'll make the motion to adopt the projections set forth on pages 1 and 2. Is that what you said?
Yes, 1 and 2 of item 4.
Of item 4. Thank you, Mr. Chairman.
I will second
Second.
that.
Okay, so we have a motion and a second to adopt the memorandum of pages 1 and 2 of item 4. And I will call the roll. Commissioner Chan,
Aye.
Commissioner Kimball,
Aye.
and this is Commissioner Payton, and I vote aye as well. Motion carries. Moving on to item 5, discussion and possible action on primary election candidate audits. Mr. Collins?
Yes, Mr. Chairman, thank you. I'm going to, these are primary election audits. We are in the process of, obviously we'll be endeavoring to finish the primary and then we'll move on to the general. My understanding with these audits is there's no significant findings. And so the rules require that we approve them, frankly, regardless of if there's findings or not. This is simply an opportunity for the commission to, review and if you have any questions or comments on the issues on those reports, obviously Mike or I can answer them. Otherwise, I guess we're open for questions or comments from you, Mr. Chairman.
Okay, any discussion from the commission? And any discussion from the public? If not, I'll entertain a motion to approve the audits identified in item 5 of the agenda.
Mr. Chairman,
Yes, Commissioner Kimball.
I move that we approve the audits in item 5 of today's agenda.
Okay, we have a motion. Do we have a second?
Mr. Chairman, I second the motion.
Mr. Chan seconds the motion, and so we will have a vote. Commissioner Chan, how do you vote?
I vote aye.
Commissioner Kimball?
Aye.
And this is Commissioner Payton. I vote aye as well. Item 6, discussion and possible action on MUR 20-04, Eric Sloane. This is an enforcement-related item. Since we're meeting virtually, I'd like Tom to introduce the item and give an overview of the recommendation, then have time for commission questions. Following that, I would like to hear from Mr. Miller, the attorney for Mr. Sloane, then Mr. Fischbach, who represents Dr. Branch, then Mr. Miller again if necessary. So, Mr. Collins, you're on.
Yes, thank you, Mr. Chairman, Commissioners. I'm not sure if we'll end up having Lee Miller or someone else from his firm, but at any rate, I don't want to put too much gloss on the recommendation. We do believe that there is reason to believe a violation may have occurred. We've outlined what we think are the issues that we've been able to identify by evaluating the complaint, the response, and campaign finance reports. I just want to stress that this is a determination that is preliminary, and as you can see from the memo and the response and the complaint, there are substantial issues of fact around the issues we've identified that there's reason to believe a violation may have occurred. So just to put this in perspective. And then additionally, if you have questions related to procedure here, we do have an attorney from the Attorney General's office who is there to answer your questions on those, just to ensure that there's a appropriate buffer. But other than that, unless you have questions or comments, I'm open to your questions at this point, Mr. Chairman, and
Mr.
Um,
Chairman?
sure.
Tom, just looking at this last night, frankly, there was just such a dichotomy between the two parties' kind of versions of events. And so just to refresh my recollection, since we do this kind of every 2 years, if we find that if we agree with your recommendation that there is reason to believe that there may have been a violation, that doesn't put a penalty on Mr. Sloane. Does that just
So
proceed with additional investigation? Is that
Yes.
how this works? Can you just kind of refresh my recollection, please?
sure, of course. Mr. Chairman, Commissioner Chan, the rules lay out the process here. So if there are 3 members of the commission who determine that there's reason to believe a violation may have occurred, we do undertake an investigation. We've outlined in the memo some of the tools we think may be necessary to do that. So the big the distinction to your point about penalties and those kinds of things. This determination is the functional equivalent of a reasonable cause determination by the Secretary of State's office. And so, as you probably recall, obviously, once the Secretary of State does that, they pass the case to the Attorney General's office. In our situation, once this determination is made, we go forth and do an investigation to try to determine from staff perspective what the facts are. There are then there are provisions related to administrative settlement in the rules that we have to abide by, and then there are also rules related to the briefing of the determination of probable cause to believe, and then the penalty question. So those are all, just to be candid, obviously those are not in every matter steps that we reach. In other words, we have often come back to the commission with a conciliation agreement, prior to that. But were the commission to determine reason to believe a violation may have occurred, it would be our goal to try to determine what those try to determine what we think how we would, to be able to be in a position to make a recommendation to the commission on what we believe the preponderance of the evidence is on those disputed issues of fact.
Mr. Chairman, and I'm happy, of course, to give time to Commissioner Kimball and yourself, but I am anxious to hear from the parties involved from their own mouths. I know, obviously there's a lot of paperwork here and documenting their claims, but just to hear from them today is going to be something I'm interested in because of the different stories they have to tell. Not stories in the sense that they're not true, but just the difference between what they have to say.
Certainly.
And Mr. Chairman,
Yes, Kara.
I just wanted to make clear that for purposes of this agenda item, Jeannie Galvin is the Attorney General or Assistant Attorney General who will be representing the commission. So to the extent the commission has any questions, they should be directed to Jeannie. And I just wanted to say thank you to her for stepping into this role and being able to provide any advice you may need.
Good morning, and you're welcome.
Thank you, Ms. Galvin. Any other questions or discussion before we have Mr. Miller speak?
Mr. Chairman,
Yes, Mr. Kimball.
I agree with Commissioner Chan that I'd like to hear from the parties. There's just such substantial disagreement on what the facts are that I'd like to hear from them. I've read this all over several times, and I really would like to hear them talk about it in their own words.
Certainly, I agree. Any other questions, discussion? Okay, Mr. Miller, if you're available, you have the floor to speak to the commission.
Thank you, Mr. Chairman, members. My name is Lee Miller with Walenchek and Bartness, here today on behalf of the respondent, Sloane 2020 Campaign Committee, and the candidate, Eric Sloane. Frankly, at this point, all I wanted to convey to you and your colleagues is that we stand by our response. Note that we received a clean audit report for our primary period activities, and look forward to working with Mr. Collins and his colleagues at the commission to resolve this matter as rapidly as we possibly can. And with that, Mr. Chairman, I'm available for any questions.
Okay, any questions for Mr. Miller from the commission?
Mr. Chairman?
Yes.
Hi. Hi, Lee, it's Amy, obviously. Can you just kind of go over for us? I know, obviously, you probably feel like you don't want to repeat ad nauseum what you already put in paper, but can you please just go over for us, boil it down, simple terms, what happened? What is the story here? Why is there this difference of facts? What happened according to Sloane, and what's the deal here?
Certainly, Mr. Chairman, Commissioner Chan. I guess to try and summarize, Mr. Sloane and the Sloane 2020 Committee entered into, we'll call it a consulting agreement with a political consulting firm known as the Power of Fives, and that Power of Fives would work closely with Sloane 2020 and with candidate Sloane, and would assist them with both gathering $5 contributions, qualifying for clean elections, and when they were qualified, frankly, with figuring out a spending plan, how Power Fives was going to facilitate Mr. Sloane being elected to the Corporation Commission. I think the most fundamental difference in perspective here is that Sloane 2020 believes that having qualified for clean elections funding, it's at that point that it would engage with its consultant and put together a budget, put together a plan. $50,000 on rural radio, $25,000 for social media, things that you would customarily see in any political campaign. What we experienced was as soon as Sloane 2020 qualified for clean elections funding, was that it received an invoice from Power Fives that simply said, pay us over 100% of the funding that you're entitled to. We're happy to chat about how that money is going to be spent, but Power Fives' view of things is that they earned the entire $115,000 and I think change as soon as Sloane 2020 qualified for clean elections funding. within days of within days of qualifying for clean elections funding, there was, we'll call it robust dialogue between the Sloane campaign and Power Fives over how the money was to be spent. Ultimately, Sloane 2020, Eric Sloane came to the conclusion that the spending plans, that the services being offered by Power Fives were not services that he believed were going to create a victory in the campaign. And so pursuant to the contract, Sloane 2020 terminated Power Fives. And then 3 or 4 weeks later, you all received this complaint. And I think that's our summary.
Thank you so much for going over it for us again like that. Thank you.
Thank you. Any other questions for Mr. Miller? If not, then we will hear from Mr. Fischbach. If Mr. Fischbach is available to speak to the commission.
Yes, good morning, members of the commission. My name is Will Fischbach. I'm a partner with the law firm of Tiffany and Bosco. Seated to my right is my client, Dr. Bob Branch, who is the principal of the Power of Fives. I'd like to make a brief statement, have my client make one as well, and I'm happy to answer any questions. Relative to the, I think the inquiry from Commissioner Chan, we agree with the chairman's position that it is up to this commission to decide today whether or not probable cause exists to move forward with an investigation. We are not asking you, and I don't believe the chairman is asking you to pass judgment at this point in time, nor would that be prudent of you to do so unless and until you have all of the facts at your disposal. Of course, it's not unusual in a circumstance like this for there to be dueling narratives of what happened. But succinctly put, the Power of Fives is not, as Mr. Miller put it, a political consulting company. The Power of Fives offered turnkey election support in both primary and general elections to multiple candidates, one of which happened to be Sloane, who also at one point used to work for the Power of Fives. Mr. Sloane signed an agreement that is clear as day as to what the obligation was, and that through phase 1 and 2 of the campaign, which is essentially through the primary election, he was obligated to pay the entire statutory amount allotted for the primary election campaign, which Mr. Miller is correct. It's $116,600. We provided the support, and under that, the terms of that contract, Sloane was obligated to pay it. In addition, the Power of Fives paid $23,000 to an attorney by the name of Tim Lasota to both challenge Sloane's opposition during the primary election, but also to defend Sloane himself when Sloane's own signatures were challenged. And the notion that Mr. Sloane was unaware of this expenditure or that he didn't authorize it is ludicrous. At one point, Tim Lasota was representing Mr. Sloane, and Mr. Sloane can't deny it. Mr. Lasota appeared to defend Mr. Sloane in the primary challenge lawsuit against Mr. Sloane. And the terms of the engagement between the Power of Fives and Mr. Lasota made it clear that Mr. Sloane was obligated to pay for Mr. Lasota's fees. And he would have done so, but as alleged in our complaint, I believe roughly in, was it July of this year, Mr. Sloane approached Mr. Branch and asked him to advance that additional sum of money of $23,000 to pay Mr. Lasota's bills. Now, I'm sure that my colleague Miller disagrees with that. I'm sure that Mr. Sloane disagrees with that summary, but that is why it is incumbent as you, as the Clean Elections Commission, to conduct a thorough investigation, utilize your subpoena power, and get your arms around what happened here. And I'm confident, and Mr. Branch is confident, that when you do that, you will find that the facts align with our version of events. I would like to see if Mr. Branch, Dr. Branch, has anything to add to that summary.
I would, and
Yes, go ahead, Dr. Branch.
Yes, sorry, sir.
Go ahead.
Oh, Commissioner and Chairman, thank you very much for letting us be here today. In July of 2019, Eric Sloane and I entered into an agreement that he would be our first candidate that the Power of Fives LLC would represent. In August, we executed that. In September of last year, now I know that Mr. Miller wants you to believe that nothing happened until Eric Sloane received his funding, but understand Eric Sloane received his funding about a week and a half prior to the primary election. We were actually running his entire campaign since a year ago. September is when we had our first expenditures. We started gathering signatures for him per his request. We started having events for him per his request. And in November of last year, 2019, he asked me for a job. I told him that was problematic since he was my candidate. And he said, well, hire my wife's firm. And he says, that's perfectly legal. You can do that. So I agreed to pay his wife's firm $4,000 a month. So when Mr. Miller wants you to believe that we had no expenditures, that's not the case. Also working on his campaign, I had former Secretary of State Ken Bennett working on his campaign, my management staff working on his campaign, and a whole host of people that were front people at events for Mr. Sloane gathering signatures. In fact, when the signatures were ultimately challenged, Eric Sloane was the only signature that was challenged that came through victorious because we funded the people to help go get those signatures. So the only reason why he is on the ballot was because of our effort. A little correction from my attorney here. In May of this year, after all of the court cases, now understand Eric Sloane went out and got Tim Lasota. I didn't even know Tim Lasota, attorney Tim Lasota. He negotiated the price with Tim Lasota on the challenges, the signature challenges, and he negotiated the price with Tim Lasota on his own defense. After all of those challenges and after all of the defenses, that's when that's when Eric Sloane and Tim Lasota both came to me and asked me, the Power of Fives, to advance him $23,000 that was negotiated by Sloane. So throughout the entire process, the Power of Fives was expending a lot of money. Now, when April came around and his signature challenge was successful, he defended it. We were still over $1,005 contributions away from qualifying. Now understand, the Power of Fives was spending all of this money before he qualified. We made agreements since Sloane and Leah Marquez Peterson were the only two Republican candidates. I entered into agreements with the Republican Party to help get behind them, those two candidates. We created, again, with former Secretary of State Ken Bennett and a few other people, plus the Republican Party. We had mass mailings. We had the calls all set up to convince people to give $5 contributions. These are expenditures that the Power of Fives made. So when Eric Sloane, when he got his funding, at that time, it was over. He won the primary, he got his funding. All of the effort was because of the Power of Fives and the money that we expended. And according to the contract, nothing more, nothing less is what we asked for. Now, the $23,000 for the legal fees, when he came to me and when Sloane came to me and asked me for them, this was after everything was, challenges were all done. I said, listen, after his attorney and he convinced me that this was legal, I said, this is a campaign expenditure. It has to be. It has to be, because my company is not in the business to loan money. We are your turnkey campaign. This is a campaign expenditure. So when I seen that he did not put that on his filing, that's when I contacted my attorney and said, listen, this is.
What we talked about is privileged.
Oh, I'm sorry. That's when I filed the complaint. That's when I contacted Mr. Collins. I want to thank you very much, Mr. Collins. It was over a weekend and you responded to me in this COVID world. And that's when I submitted my complaint.
Okay, any questions by the commission for the two men on the screen?
Mr. Chairman,
Yes, Mr. Kimball.
Tom, I wonder if you could get into briefly a discussion of why what on the face of it is a contract dispute between these two parties is now a clean elections matter.
Mr. Chairman, Commissioner Kimball, that's a good question. I would say this about that. The Act provides for what to do in the event of a contract dispute of this nature, and Mr. Miller contacted me about that, and under the terms of that statutory provision, as the response notes, there's some amount of money. I'm not gonna rely on my memory to state what it is, but there's some amount of money held back from the primary to deal with that. There's also a pending arbitration schedule. My view on this is that we have there are two interests here. One, there's an enforcement issue that I believe there's reason to believe a violation may have occurred. And then secondly, because of the substantial issues of fact, there's an overall question about whether or not, and we want to develop to examine, I should say, some of the expenditures here. Now, it may be that the arbitration, it purports to resolve some of those issues. I think that my viewpoint is that rather than deferring this determination until after the arbitration is completed, the determination here on its face would empower the staff and it to ensure that the commission's interests, which are separate from the parties, are looked after. Whether or not and how we address that in the context of this arbitration, I'm not frankly in a position to tell you. That is something that I think that we would anticipate, talking to both sides about that issue once we're empowered to ensure that the commission interest here has has the essentially that my actions and the actions that other staff members or attorneys might take are authorized under the commission's rules. So it's really out of a sense of prudence from my perspective that we recommend the determination be made now on this preliminary question, because it will give us an opportunity to evaluate, how we ascertain the necessary facts and how the arbitration proceeding would fit into those, fit into that. I'm not prepared today, for example, to say, because this would be the effect of not making a determination, I think. What I'm not prepared to do is say, or to recommend, and this is obviously your decision, not mine, but say, let's let the arbitration take its course, and then whatever comes out of that, we'll deal with. The reason being that, because without the authorization, I don't know how to engage with that process in a way that can ensure whatever the commission's interests, whatever we sort of think the commission's interests may turn out to be are taken care of. So I guess what I'm trying to say is that obviously, but for the complaint, we wouldn't be here. But that having been said, again, I think that because this is a preliminary determination, I think that it's in order for us to feel, comfortably empowered within the rules of the commission to get in, to be aware of, and to potentially have to take actions in this situation, we would recommend not waiting until the arbitration resolves. I hope that answers your question. I know it's a long answer to because the real answer is I don't know yet. But I don't want to wait, or my recommendation is not to wait until then to determine probable cause, or not probable cause, to determine whether it's reasonably the violation may have occurred.
So could you talk a little bit about what kind of timeline you would envision this taking? Is this something that you would come back with it if we were to move forward? Would you come back with a recommendation in a month, or is this a very lengthy process?
Mr. Chairman, Commissioner Kimball, I would say this about that. We're, as Kara noted, helpfully, for the record, we have things set up in such a way where, you'll have counsel on the proceedings, and we will have counsel on our investigation. Those will be separate, and that's in order to ensure, that everybody has ample process. I think that with this authorization, we'll be able to engage a little bit more in that evaluation. I will say this, unless there's a contrary rule, and I don't think that there is, provided that, ex parte and other things are dealt with, we could obviously update you on where the arbitration question gets us once we staff and Kara have an opportunity to be engaged in the process. I think that we can work with the parties with the respondent, really, ultimately, and then obviously we'll be working with the complainant as well to make sure that there's that appropriate communication of our progress is made, subject to all the due process considerations that go into that.
If I may, this is Jean Galvin, Chairman Patton, and members of the commission. I would suggest that you make your decision on whether to move forward separate and apart from the status of the arbitration. You clearly have jurisdiction over the campaign issues, and I would recommend that you evaluate what you have in front of you, decide whether there is merit in the filings and whether the investigation should continue. And at this point, not worry so much about the arbitration. Let the parties do that part of it, and then you exercise your authority with respect to the material that you have in front of you.
Mr. Chairman?
Yes, Commissioner Chen.
Mr. Chairman, Ms. Galvin, I'm so disappointed to hear you say that because frankly, hearing Commissioner Kimball's question, I should say, I actually had that same thought, which was, one, I wanted to ask the parties, and forgive me if it's in the paperwork, have they proceeded to arbitration and are they planning to if they haven't? Because if we get involved, I do think there are substantial issues of fact, obviously. This is a contract dispute that needs to be sorted out for us to determine. I don't disagree that there is reason to believe a violation may have occurred depending on which way the contract dispute goes. For us to get involved and try to figure that out when there's an arbitration clause between the parties seems like a lot of duplication of work if there's going to be an arbitration. That's what I'm concerned about. Not that that's not our role, but if there's going to be that already, should we be getting involved there? So I guess that's more of a comment, but that's why my thought process was also going to the arbitration. Can one of the parties maybe jump in and let us know, is that going forward?
This is Will Fishbach here, counsel for the Power of
Yes.
Five. Arbitration
Go
hearing
ahead.
is for, I believe, January 13th of next year. But it is coming up. However, I would agree with Jane Galvin that they're two separate things, and one doesn't necessarily govern the outcome of the other. And it is, you've heard the phrase, sunlight is the best disinfectant. The origin of that phrase is from a book of essays by Louis Brandeis called Other People's Money and How Bankers Use It. I think the question for this commission is the citizens' money, the citizens of Arizona, and how Mr. Sloane used it. And that is certainly within your purview, regardless of what happens at the AAA arbitration.
Thank you, sir.
Thank you.
Any other questions or comments?
Well, Mr. Chairman, I'll just make
Yes.
a comment. I'm inclined to go with Tom's recommendation, just with the caveat that, I guess there's no caveat. I don't think there's any harm in going forward. I think, if there's no there, then there's nothing that will come of it. I think obviously we've kind of aired this out. We've gotten a lot of information from the parties, both on paper and today here in the meeting on the record. I just hate to see, what happens between parties that originally started out as friends, so to speak, or colleagues. So I guess I would just put that forward. And thank you, Ms. Galvin, for stepping in today and for your advice.
You're very welcome.
Commissioner Kimball, anything else?
Mr. Chairman, I would make a motion that we determine that there is reason to believe that violations of the Clean Elections Act and rules may have occurred, and that the executive director is empowered to move forward with a further investigation. I hope I worded that correctly, Tom.
Before we get that far, I want to say something myself. I'm a lay person, and this is something that I think a light needs to be shined. Obviously, there's two widely divergent sides to this, and I feel like I need somebody to go through this step by step, and this is state money that we are entrusted with, and we have a responsibility to make sure that it's used correctly and in line with the law, and to give us credibility with the electorate. And so I certainly believe that we should proceed on with this. There may not be anything there, but that way we will know exactly what's going on. So going back to your motion, I accept that motion. Do we have a second?
Second the motion, Mr. Chairman.
So Commissioner Chan seconds the motion. So we are going to vote on whether we proceed with a reason to believe that there was a violation here. Commissioner Chan, how do you vote?
I vote aye.
Commissioner Kimball,
Aye.
and this is Commissioner Payton, and I vote aye as well. So the motion carries. And let's see, where are we going? Item 7, does any member of the public wish to make comments at this time? You may also send comments to the commission by mail or email at ccec@azcleanelections.gov. If we don't have, go ahead. Yes, Mr. Chan.
I don't know if there's any other public comment, but I wanted to give a shout out to my children who are watching on YouTube. They found out I was going to be on YouTube and they got very excited about it. So shout out to my 6 and 8-year-old watching us on YouTube.
You're famous. Okay. Item 8, motion to adjourn. Do I have a motion to adjourn?
Mr. Chairman, I move that we adjourn the meeting.
All right, we have a motion to adjourn. Do we have a second?
Second.
Second by Commissioner Kimball, and we will vote. Commissioner Chan.
Vote aye.
Commissioner Kimball.
Aye.
And Commissioner Baden, I vote aye as well. Thank you, and have a safe rest of the December.
Thank
you
you.
very
Take
much.
care. Bye-bye.
Bye-bye.